Good afternoon, everyone, and welcome to this FedSoc forum discussing the legal significance of the landmark verdict in the Fox-Varian case, the future of detransitioner claims nationwide, and the emergence of a new frontier in medical malpractice litigation. My name is Anna Pusey, and I am VP of Communications and External Affairs here at the Federalist Society. We're joined today by an outstanding group of experts, including Aaron Hawley, chair of Lex Politica's Supreme Court and Appellate Practice and senior counsel at Alliance Defending Freedom, Mark Trammell, CEO for the Center for American Liberty, and moderated by Sarah Perry, Vice President and Senior Legal Fellow for Defending Education. We're also excited to have Mary Margaret Olahan, author of Detrans, True Stories of Escaping the Gender Ideology Cult, and White House correspondent for the Daily Wire, join us for special remarks at the close of our program, reflecting on her research on the ground. If you have any questions throughout the webinar, please submit them through the Zoom's Q&A feature located at the bottom of your screen, not the chat, so that we'll be able to access them later. As a reminder, all opinions expressed here are those of our speakers and not of the Federalist Society. With that note, I'll turn things over to Sarah to start the program, and thank you all so much for joining us today.
Thanks, Anna. So about 2.5 years ago, Merrill Matthews, who was a scholar at the Institute for Policy Innovation in Dallas, wrote an op-ed in The Hill entitled, "Here Come the Detransitioner Lawsuits." Now, notably, this was 3 years before the Supreme Court's watershed United States versus Scrimeti decision, in which it upheld Tennessee's ban on so-called gender-affirming care for minors as a rational exercise of the state's police powers and as a regulation based on age and medical diagnosis. But since then, Matthews's prediction has proved prescient. In fact, 28 lawsuits have been filed by detransitioners since 2022, and roughly 12 of them remain active after having survived motions to dismiss or settlement discussions. But it was only just 3 weeks ago that a young woman by the name of Fox-Varian, a 22-year-old who previously identified as a boy in her teens, won a $2 million verdict in a landmark lawsuit against New York doctors accused of pushing a double mastectomy on her when she was a minor. She had the surgery when she was just 16 years old after getting approval from a psychologist and a surgeon, both of whom the jury found liable for medical malpractice. And on January 30th, the total award was made of $1.6 million for past and future pain and suffering, with an additional $400,000 for future necessary medical interventions. Hers is the first detransitioner malpractice suit that has been successful in going to trial and ultimately achieving a verdict. So we want to talk a little bit today about where the liability stands and what this might portend for the future of litigation related to medical malpractice and detransitioning. So I'll begin sort of with an opening salvo here and a question that will set the tone for both of my excellent panelists today. But I want to go first to Mark. Knowing what we know about the fact that she was 16 years old and that she had diagnoses of certain comorbid mental health conditions, such as autism spectrum disorder and anxiety disorder, do you think a $2 million verdict was sufficient in this case?
I mean, how do you put a price tag on the damages that this young person suffered, right? When a 13, a 14, a 15-year-old has a double mastectomy, is put on puberty blockers, I say that with the scare quotes around them because it's the off-label use of drugs. Lupron Depot is often used as a puberty blocker for young women. This is a drug designed for prostate cancer patients. It has terrible, terrible side effects, including potentially losing the ability to have children later in life. So $2 million is a terrific victory. We should all celebrate this victory. It is a landmark victory. I do wish the court would have awarded a little bit more money, quite a bit more money actually, because again, how do you put a price tag on a young woman's ability to have children later in life? What these doctors are doing should be criminal. And so, yeah, $2 million, it's a great victory, but I would love to have seen it be a little bit more.
Interesting. I think that was my take as well. So, Aaron, I'm curious as to what your response was, understanding that she was 16, that this was a procedure that was approved by both of her doctors, both the psychologist and the treating surgeon, and the fact that she had comorbid mental health diagnoses, which I find sort of distinct in a lot of the features of some of this detransitioner lawsuit. These are not the underlying issues, right? The gender dysphoria that we see is very much a representation of an underlying mental health condition. So, what's your take on the $2 million jury verdict? And did you wish it was, as Mark does, a little bit bigger?
I think I do. And if you think about this, this is a 16-year-old girl who can't get married. She can't drink alcohol. And yet she's pushed into something with sometimes as little as a 30, 75-minute consultation with a doctor and says, yep, you're good. We think you are a good candidate for a double mastectomy. That's not good medicine. On the bright side, although 2 million seems paltry for this harm she suffered, it did trigger obviously a huge news wave. It also triggered the Plastic Surgeons Association. I'm not sure what their name is, but they since that verdict have now recommended all of a sudden that folks not do these sorts of sex surgeries until patients are 19. So that is a huge victory. Not enough for her, but a huge, I think, tidal wave in showing that these surgeries are too dangerous.
That actually is a great teeing up of where I want to go next with this discussion, which is really the importance of evidence in these types of cases, right? So I think all of us noted distinctly Thomas's concurrence in the U.S. versus Scrimetti decision, in which she discussed the problems of deferring to the so-called expert class, right? This is science on which we know that there are sort of shaky foundational elements. You did mention the American Society of Plastic Surgeons, who's now recommended waiting until the age of 19. We saw a watershed HHS report in November of 2025, the first to look at 17 systematic reviews, both of which together have sort of indicated, listen, this is necessary to be a watchful waiting approach. We've also seen sort of the bulk of approaches in Western Europe as well, who have begun to back off earlier representations of transing early and transing often. So a number of medical associations, in addition to the watershed CAS report that we saw, have sort of come together to represent what we see now as something with, again, shaky foundational elements. Aaron, to your mind, and somebody who's worked in the regulatory environment, what importance does the evidence have in these cases? And is it something for which we understand evolving standards are going to need to adapt? Does that hinder the litigation we're seeing right now?
So I don't think it hinders it. I think it shows what folks who think about these issues have always known to be true. It's not good medicine to take healthy reproductive tissue from a 13-year-old girl. There's just no world in which that is something that is okay. But I do think the evolving science is so encouraging. If you look at just two time periods, if you look at the time period between which the Biden administration, if you'll recall, they actually instituted the Scrimetti lawsuit. Probably regret that in hindsight. But the Sixth Circuit had upheld Tennessee's law. And the Biden administration said, you know, we're going to take a shot at the Supreme Court. We're going to challenge that. And in their petition, the Department of Justice, the Solicitor General's office, said that there was overwhelming evidence that the benefits of gender transition drugs had more benefits than they did risks. As you may remember, Justice Alito really pressed Prelogar on that point at oral argument, and rightly so.
Yeah.
That it's simply not the case that you can say anything close to what that brief said.
I have a related question, Mark, because we've talked a little bit about science. Let's now talk about policy. And I want to talk about the ability or inability to square so-called gender affirming care, particularly so for minor young girls, with laws that ban female genital mutilation, which is a cultural practice in some nations, but 41 states have distinctly outlawed that ritual cultural practice, which the U.S. Department defines as as obviously cutting procedures that are very much in relation to what we see during gender affirming care. In fact, even in these 41 states, children cannot consent to the practice, even if their parents want the practice performed for them. How do we square that circle? Can we, between so-called gender affirming care, specifically so for females, and the laws of 41 states that actually ban a nearly identical practice?
Sarah, if I'm understanding the question correctly, I would just say, look, this is child abuse. What's going on is simply child abuse. I don't think we have to overcomplicate it. If a child believes that he or she is a pirate and says to his or her physician, I want you to amputate my leg from the knee down and put a peg on it, every single adult in the room would say, no, I'm not going to do that because it's abusive. The same is true here. This is a very unique area of medicine where physicians, because of a lot of outside pressures, financial pressures, political pressures, are handing minors, 13-year-olds, a prescription pad and giving them the authority as the doctor in the room. And to Aaron's point earlier, with respect to this mounting evidence to show that this is really harmful, the policies are following the evidence, right? We filed a case at the Center for American Liberty. We're working with some terrific law firms, Lamandry and Jonah. We're also working with the Dillon Law Group to represent Chloe Cole. Chloe is probably the most recognizable detransitioner. We filed this case 3 years ago. For 3 years, we've been fighting with Kaiser over this threshold question of whether it will be decided in arbitration or in a very public trial. But 3 years ago, when we filed that case, you can look at the documents. They're on our websites. They're our co-counsels. They're on all of their websites as well. We cite to these studies. These studies are not new. More are waking up to the reality that this is abuse that's happening to children. And so I think it's absolutely within the state's power to protect vulnerable kids from being abused by adults.
That's a great point, Mark. And that actually, it goes to something else that I wanted to address, which is the diminished capacity of minors, right? The understanding of the importance to get informed consent and whether or not minors can actually give that in the first place. We legislate all the time to regulate behavior based on the fact that individuals, for example, under the age of 21 cannot purchase alcohol. We restrict their ability to buy cigarettes or register for the draft or sign a contract. But thus far, it does not seem that the detransitioner cases, the medical malpractice cases, have been related to or sort of hampered by the Supreme Court's longstanding notion of what constitutes the diminished capacity of minors. And I'll just quote from one of those cases right now. In a case called Parham versus JR, the Supreme Court wrote that most children, even in adolescence, simply are not able to make sound judgments concerning more decisions, including their need for medical care or treatment. Therefore, parents can and must make those judgments. Now, admittedly, that was Parham versus JR in 1979. So we are in a new era at the sort of litigation here in medical malpractice and detransition. But to Aaron, your mind, what is the sort of disconnect between what we understand the Supreme Court's jurisprudence to be on the diminished capacity of minors and why we don't see that becoming more of an issue right now in the medical malpractice phenomenon with detransitioner litigation?
So it could be because there's sort of two things going on here. If you look, think back to this Kermetti case, the ACLU in that case also pressed sort of a parental rights theory. So to be quite frank, a lot of doctors have scared parents. You talked about Chloe Cole, and she'll tell the story how her doctors, the people who were supposed to be taking care of her, told her parents, do you want a dead daughter or a live son? So that's the message that parents have been hearing for decades. So you do have some parents that are supporting this because they think that's their only option. That's what they are told. But when you look at the facts, just to pull one of these cases, there's so many horrifying facts. But if you look at this, one of these girls at the center of these lawsuits that Mark and others are bringing is a girl named Kayla. When she was 11, she came across a social media influencer who was promoting transgender ideology. At 12, she was prescribed, or actually at 11, sorry, she was given puberty blockers. After a 75-minute consultation, she was recommended for hormones and surgery. So this idea that someone who is 11 or 12 years old, I think she had the surgery when she was 13, can possibly comprehend that with that action, she's not going to be able to nurse a child, all sorts of risks like that. That's just incomprehensible to me. That for 13 years old is just crazy.
It's interesting because it really does fly in the face of so much of our established case law on the nature of the parent-child relationship and the fact that parents are assumed to be acting within the sort of best interests of their children. And this is part of the complication I think we see with detransitioner litigation, right? Because a lot of the parents are being very much bamboozled by what they have been told and being sort of manipulated, for lack of a better term, on sort of the emotional vulnerabilities that any parent has, which is, would you rather have, a living daughter or a dead son? These are the kinds of sort of emotional appeals that I think have resulted in widespread profitability in this particular type of industry. And it really does not square with what we've understood about a child's understanding or lack thereof when it comes to the lifelong consequences of their decisions. I'll give you another case, Roper versus Simmons. And for anybody who's sort of a Supreme Court history nerd like I am, this is a case you'll want to look up. That was a case in which the court wrote that a child's lack of maturity and underdeveloped sense of responsibility lead to recklessness, impulsivity, and risk taking. They are more vulnerable to negative influences and outside pressures. That in and of itself really should be emblazoned across the arch of the American Medical Association, because it is one of those situations where we've ignored what the Supreme Court has iterated over and over again, but we've also ignored basic standards of care when it comes to the understanding of the consequences of one's decisions when it comes to medical choices like this. And I actually want to take one of the questions that we've already gotten from our audience members, and I have many more to ask, but this is an important point. It goes directly to what we're discussing. Dan asks, I understand that liability was based on the doctor's failure in the Fox variant case to follow the standard of care, such as it was at the time. It sounds like the standards of care have changed or are changing. So speak to that a little bit, Aaron. What are sort of practitioners, both legal and medical, to do with the fact that the standards of care are really on a bit of a sliding scale right now, as we've seen a lot of these previous representations now sort of backwalked from their original sort of strenuous representation that it was gender affirming care was the only option?
Sure. So I think it's really good news going forward, with the plastic surgeons saying you need to be 19. But looking back for practitioners, it seems like there's a couple of arguments to make. One, perhaps the standards of care weren't themselves permissible. If you look at the WPATH standards, for example, they have bowed to all sorts of political pressure. They originally did have in place an age limitation for surgeries. And they removed that at the behest of political pressure. So if you're looking at standards, maybe those standards themselves are subject to challenge. In addition, I think what Sarah has been talking about is so important. Even if theoretically a doctor complied with standards of care, it is inconsistent with a doctor's requirement of providing good care to their patients to not get informed consent. I think in many, maybe most of these cases, informed consent is just impossible. And that's why you see informed consent claims in addition to breach of the standards of care.
Mark, let me go to you for a second. You guys have really been at the Center for American Liberty at the vanguard of all of the litigation and really were some of the first ones to pull the trigger on this, to recognize that there was an opportunity here to litigate because these young women were experiencing the lifelong consequences of a decision made when they lacked the requisite maturity to do so. Talk a little bit about your litigation. You mentioned it briefly. Do cases like yours and does your litigation, do they all bear certain unifying or common characteristics?
It's a great question. I think they do. we've brought a few of these cases. There's been a ton we haven't filed, and we haven't filed them, for a variety of reasons we can probably get into later. But I think what's common amongst most of these potential cases is they're overwhelmingly young girls. I think if you look at the statistics from Kaiser and its own gender hospitals across the country, but especially if you look in Oakland, California, you'll see that the overwhelming number of patients they have are receiving double mastectomies. So these are not young boys, these are young girls. There's also a commonality here with respect to comorbidities. So many of these kids are suffering from a range of comorbidities, everything from anxiety to ADHD to autism. Oftentimes that's undiagnosed, to issues of self-harm. We have several clients who were sexually abused as early as the first grade. One of the cases that we've worked with other counsel to bring and we've helped fund is Clementine Breen's case. Clementine brought her case against the Children's Hospital there in Los Angeles, and Joanna Olson Kennedy. Clementine's very open about, as an elementary school, I think in the first grade, suffering from sexual abuse. And then upon hitting puberty early and starting to being treated differently, that really triggered trauma. And I think if doctors at these gender clinics were doing their due diligence, they would know that the surgical intervention that they're prescribing, or rather that they're giving these kids to prescribe themselves, is not going to solve these comorbidities. It's not going to solve these issues. What these kids really need is counseling, significant amounts of counseling. What's challenging here is that there's really, we don't bring these in any of our lawsuits, but I think there's a huge First Amendment issue here as well that needs to be discussed robustly nationwide, and what doctors are allowed to say to patients and what they're not. I think there's a growing fear among practitioners that if they counsel their patients in any direction that is not an immediate affirmation, that they could lose their medical license. That's a real problem. That's not putting patients first.
So I'm going to transition briefly because Mary Margaret Olahan is on the line. She is a White House correspondent for the Daily Wire, but she's been able to join us. She was in the White House briefing room today. So we know you've written on this, Mary Margaret. Welcome to the webinar, and I'm turning the floor over to you.
Well, hello, everyone. I apologize for my tardiness. I just got out of the briefing, but I'm so grateful to be part of this conversation and just to discuss this incredibly important landmark verdict granting justice to a young woman, a detransitioner. Fox Varian, as I'm sure you've discussed, has been awarded her $2 million in a malpractice verdict related to her attempted gender transition when she was just 16 years old, one that resulted in her undergoing an irreversible double mastectomy in her fruitless attempt to change from a girl to a boy. Now, Fox's story is tragic, but as Max was sharing, it is also unfortunately so similar to the stories of so many other detransitioners, young men, but mostly young women who attempted to do the unthinkable. And for many of these young people, they were struggling with issues at home. I believe this was discussed already as well. Many of these young people are coming from broken families. They're on the autism spectrum. They're not aware of this. They've experienced sexual abuse or sexual assault. Most often, what I have heard and what they've told me is that they felt uncomfortable in their own skin. They failed to feel that they fit in at school. They were awkward and lonely, and they sought comfort online. And here they inevitably met with the lies of transgender activists who would urge them to believe that they were, in fact, born in the wrong body and that they needed to transition in order to be happy, and that anyone who disagreed with them hated them and wanted them to be dead. And I know I sound fanciful when I say such things, but it sounds much grimmer coming from the mouths of the trans activists who do, in fact, say this to these desperate young people who absolutely buy these lies. Now, I've been told by many detransitioners that they also encounter transgender ideology at school, where we all infamously have heard these stories throughout the past several years where teachers and therapists and counselors encourage them to regard transition as the solution to their problems. And when these young people inevitably go to their parents and reveal that they identify as transgender, and must undergo these so-called gender affirming surgeries and hormones, the parents are most often astonished and horrified. And I know we often hear about these horrific parents who push these children down the path to transition. I think in my experience, in my reporting and the stories that I have learned, that's actually not usually the case. What I have found is that the parents are usually horrified and don't want their beautiful daughter to do this type of thing. And they don't know what to do. They're usually at a loss for how to handle the situation. And while they might protest and push back, they ultimately take their child to the doctor and say, "What should I do?" And time again, they're told the same lie, that failing to transition their child will cause their child to commit suicide. And they are given the exact same line over and over: "Would you rather have a dead daughter or a living son?" And that's a line I have heard, and I'm sure many of you have heard from detransitioners, from their parents. It is an evil, evil lie. And so many trusting young people have turned themselves over to the gender surgeons, who then hack away at their youth, at their innocence, all in pursuit of an ideological lie. Now, I have spoken with a number of young men and women who deeply regret their attempted gender transitions. I wrote a book on their testimonies, their stories, and many of these individuals, again, mostly girls, are thankfully pursuing legal action against the doctors and therapists who push them down these paths. Fox's case in this specific instance has made history. And for many of us who've been waiting for this to happen, this is a pivotal moment. A judge has ruled that her doctors committed medical malpractice when they approved and performed a double mastectomy on her, saying that they violated the standard of care by failing to obtain meaningful, informed consent to perform the surgery. This is what we've been hearing from so many young people for years now, that they did not fully consent to the surgery because they didn't understand what was happening. They were not given the full information. Their mental health was so devastated that they couldn't make a solid decision in the first place. And this case signals not only that detransitioners can really obtain some sort of justice after the years and physical and mental pain that they endured, but it also signals that doctors and mental health professionals can be held accountable for the harm that they're doing to our youth. It's something that many of us have wondered for a while, whether this would in fact be possible. And it signals a new frontier in medical malpractice litigation, opening the door to new standards of care, informed consent, and much more. I believe we should be bolstered by this news, but we should also be prepared for action. There's so much work to be done to protect our children and to obtain justice for those who were treated so cruelly. And I'm excited for conversations on this to continue. And again, I must apologize. I'm at the White House, and the news just never stops here. So I apologize for the background noise.
Thanks, Mary Margaret. We really appreciate you jumping on. Again, we know that it's sort of a challenge to juggle multiple things, and you clearly had an important function to do today. Mark, I want to go back to you really quickly, because you did mention briefly the First Amendment context, and I think it's interesting because we actually just heard the Supreme Court hear oral arguments in the Charles versus Salazar case, right? This is an individual under a so-called conversion therapy ban who has, again, in the state of Colorado, who can't seem to get out of its own way when it comes to the First Amendment. And we should know we are one of the organizations that's actually suing them on First Amendment grounds. She's actually said she wants to be able to counsel in accordance with her deeply held religious and medical beliefs when it comes to best practices, and that is accepting natal sex, accepting who you are. And those are conversations, I think, that are going to play out significantly going into the future. It is one of the Supreme Court's blockbuster cases, probably will not be issued until, I would guess, close to the end of the term. That would bring it in around June or so. But do you think that the First Amendment considerations are going to be sort of continuously front and center when it goes to what doctors and their patients can communicate to one another and what messages can be transmitted?
I do. I think it's monumentally important because there's censorship happening in doctors' offices right now. To maintain medical licensure, doctors, like lawyers, have to do continuing education courses, and a lot of those continuing education courses require physicians to select what the correct course of treatment would be in a particular hypothetical, and they're training these physicians annually to affirm only, and that affirmation only approach is proving to be very dangerous for young people. I do think the First Amendment issue is going to be impactful on these cases in the long term. However, I think these cases, given that they're filed, these are medical negligence cases, right? We're not litigating constitutional questions, which is really why none of those claims are present in any of these lawsuits that we're at least working on. I don't know if I don't think I've looked at every single complaint that's been filed. I'm unaware of these claims being brought in other detransitioner cases. But I think where this is going to play out is now that there's a $2 million award of damages, I'm hoping that more and more detransitioners will see that there is hope. With these cases, it's very hard. It's very hard for any victim of a crime or any victim, and I say crime here, very purposefully, because again, I come back to this point. It's child abuse what they're doing to these kids, but it's very hard for these young people to put their name on a lawsuit and announce to the entire world that they may or may not be able to have children, to announce to the entire world that this is the damage to their bodies and their reproductive organs. And to be able to do that at such a young age, and they have to do it at such a young age. A point that I referenced earlier is, for every Chloe Cole, there is a Kayla Lovedahl. And Aaron referenced Kayla Lovedahl's case a few questions back. Kayla's case was decided in arbitration, and ultimately it was dismissed. It was dismissed because of statutes of limitation. In California, you have 2 years to file your lawsuit upon recognition of the injury. Kayla had a double mastectomy at 13 years old. How does a 13-year-old hire a lawyer within 2 years of recognition of the injury? How does that happen? I mean, we filed that case. We knew it was a little bit of an uphill battle on that, but made certainly very strong arguments of continuing care that the arbitrator, just flatly rejected. And because it was an arbitration, that's not appealable. So no justice for Kayla Lovedahl. These cases, though, I think are just going to, I think more and more are going to file. Now that they've seen you can win, because again, up until now, you've seen a lot of cases dismissed, and largely because of statute of limitations. But seeing that there can be a win, there can be an award of damages, I think it's bringing a lot of hope to a lot of young people who are now willing to see that they're not going to be by themselves if they're standing up filing these lawsuits. There are a lot of other young people who are also filing these lawsuits. The next lawsuits I would just alert everyone to keep an eye on. Luca Hine, we're very hopeful that Luca Hine's case will be litigated perhaps early next year. We have a scheduling conference later this spring, so we'll have more information on that soon. And Chloe Cole's case has been set for trial April 5th, 2027. I have to think a minute what year we're in this year. But as these cases continue to be litigated and are in a very public trial, so that reporters can go there and report from the gallery the evidence that's being introduced, again, opening the eyes of the American people, I'm very hopeful that this verdict will really do a lot of good and encourage a lot more young people to file suits similarly.
So the WPATH, the World Professional Association of Transgender Health, the standards there for the evidence and whether or not the evidence was ever in question was not an issue in the Fox Varian case. This went directly to what is a prototypical element of all medical malpractice cases, and that's the standard of care. But Aaron, I want to ask you, in sort of relation to WPATH as being sort of the tip of the spear when it comes to the world's acceptance of the efficacy or suitability of so-called gender affirming care for minor children, do we think we're ever going to see litigation, medical malpractice litigation, in which those particular standards themselves from WPATH are called into account? Will they be the subject of litigation at any point in the future, to your mind?
I sure hope so. If we look at the way those standards have evolved, it's clear that they have given way to political pressure I mentioned earlier, the Biden administration is pressuring of WPATH to not set age limits for these sorts of surgeries, which they were happy to do. They also suppressed a study from Johns Hopkins because that study showed risks and it didn't show the benefits that they wanted to promote. So this is an organization that suppressed evidence. It's an organization that's bowed to political pressure. So absolutely, I think and hope that we will see those standards being challenged. And one thing I'd love to know from Mark is if they're seeing any of the sort of smoking guns that in the infamous Ford Pinto case. And what makes me think of that is I was recalling the Vanderbilt quote from the doctor. We all saw this a few years ago, which of course, she was talking about how much money this would make the hospital. And looking at it again, it's worse than I remembered. This is a doctor. She's caught on tape in 2018, and she says that these surgeries, okay, this is put down some costs of how much each patient would bring in, and it's a lot. Then she talks about how double mastectomies can bring in 40,000. She talks about how much bottom surgeries on men can bring in, and then she says, and to female and male bottom surgeries, and I'm quoting, these are huge moneymakers. It has to be an underestimate, but they're quoting 20,000. But there's things I've read that it could be up to 100,000. It says there are entire clinics that are supported just based on this procedure, require a lot of ORTM, and they make money. They make money for the hospital. Like, I don't even understand that sort of sentiment when we are talking about 13-year-old children.
No, I would agree. And I think a bigger question to answer here is whether or not we think medical malpractice current frameworks and litigation are sufficient to handle the demand of what we're going to see going forward. Do we need to start thinking about other opportunities for recovery for these young people when they get to the point where they recognize the consequences of these lifelong decisions? Or do we have sort of in tort law, in medical malpractice, enough of a framework to be able to bring justice and relief to these individuals? What's your take, Erin? And then Mark, I want to hear your thoughts on that question too.
So just to piggyback on something that Mark said, the 2-year statutes of limitation in California, that's absurd for a 13-year-old girl to need to, as Mark said, hire a lawyer by the time she's 15. So states are, as many are pushing out that statute of limitations, which is a really good step, at least until children reach the age of majority. But there are hurdles to litigation. It's expensive. Sometimes you can find a pro bono lawyer, sometimes you can't. You have to put your name out there. I'm sure these individuals suffer harassment, all sorts of things. It's a huge undertaking. So I'm hopeful that it will be the line in the sand that causes doctors to think twice about doing these sorts of dangerous surgeries, again, with hardly any consultation. So I hope so, but it's litigation is always an uphill battle.
So this is a question that's not directly related to the notion of medical malpractice and standards of care and what we saw with this jury verdict, which was exceptional and the first of its kind. But it's sort of a tangential area of law within the concept of family law. And Nathaniel's asked a question that I think is very germane to this, because often, especially so in parents who are separated or divorced, there are two different perspectives on whether or not a minor individual, a child of both of those parents, should move forward with medicalization of gender dysphoria. Do we have any perspectives on, and family law is not my area of expertise, and I know you guys are not necessarily in that space, but we've seen increasing conflict within the concept of family law as to what happens between one parent and another when they have two different perspectives on medicalization of those minor children. Where are there avenues to relief, or is that simply a question of getting to states where we have better family court systems with better family court judges?
Who wants to answer that question? Sarah, I'll jump in for just a moment.
Sure.
Every one of these, I'm sure Erin's had a lot of calls as well. That very fact pattern that you've described, Sarah, I know we have as well at the Center for American Liberty. Every one of those situations is unique, right? And those cases are being decided on a case by case, very fact sensitive bases. And so there's not a clean answer. I really just truly believe there's not a clean answer. We've helped a few cases over the years where it's been like a dad who's wanted to protect his child from detransition, and what becomes really crucial is, especially when they're in different jurisdictions, mom and dad are divorced and they live in different jurisdictions, and one is certainly more friendly of a jurisdiction to this type of barbaric procedure than the other. I don't know that I have a much better answer than that, other than just to say each one of these cases is enormously hard, and they're decided on a case by case. I think they can be resolved over time, because I do, to kind of address the previous question, I do think there is a lot of room within tort law to fix this problem.
Yeah.
When Chloe went on Laura Ingram's show to announce her lawsuit 3 years ago, Laura made a very good observation. She said, "This is the tip of the spear. This is like big tobacco litigation." And I
Yeah.
think that that's true. And, our goal has always been, we want to demonstrate to the legal community that you can do good, and you can also recover your attorney's fees in doing good, right? We're a small shop. We have a handful of lawyers who work for Center for American Liberty. We have no intention of trying to bring or fund every single one of these cases. But what we want to do is we want to demonstrate that there's a way to do this. This is how you do it. You can be successful. And then lawyers who want to make a dollar and do something good with their day can take up these claims as well. Eventually, when enough of these claims are brought, the question of whether which parent is deciding will be kind of moot, because doctors just won't do the procedure because it's going to be too much of a liability for them. Their insurance providers won't provide the insurance coverage for them to do these types of procedures on minors.
Yeah.
That's where we have to get. And I think we're on that path, but we have a long way to get there.
Yeah, it's actually very interesting that you bring that up. And in fact, there was evidence that Fox's estranged father tried to stop the surgery and apparently told the psychologist that he didn't consent, but there was no communication between the psychologist and the plastic surgeon. That may have played significantly into whether or not the actual evidence that was presented provided the actual standard of care that was necessary, whether or not there was sufficient communication, whether or not they used ordinary sort of regular guidance procedures. But I want to get to the question of malpractice specifically, because that is something, and insurance, because right now we are seeing automatic insurers begin to reassess their coverage for gender clinics, and state legislators are renewing debates over the ethical and financial accountability of institutions performing these surgeries on minors. And again, this is a $10 billion a year enterprise. So what theories, and I'll turn this over to Aaron. So Aaron, what theories of liability do we potentially have at our disposal when we are sort of investigating the role that potentially private insurers have to play in some of this?
Sure. And I think that maybe the step even before that, and my understanding is that most of the existing lawsuits do include the clinics, they include the hospitals. And that not only is, the bigger pockets that can sort of send a message that if you do these sorts of dangerous procedures, you may be on the hook as a hospital for a lot of money. And that's going to give those hospitals who were sort of crowing over all the money they were going to make, that's going to give them significant pause before continuing these sorts of things. So I think, suing the hospitals, suing the clinics is hugely important. Those are the sort of administrative entities that will decide whether to hire the doctors that do these sorts of things. But I think it's a really interesting question as to insurance as well. What role do insurers have in facilitating this sort of thing? I'm not aware of any case that has held, other than Kaiser. Kaiser's kind of a self-insured sort of situation where they both provide the insurance and the medical care. But I'm not aware of cases that have directly challenged the insurers. But it's an interesting question. Certainly, state law could prevent, or I should say, certainly federal law could prevent taxpayer money from going to plans or Medicaid that fund these sorts of things. So that's one avenue, I think, to look at the insurance angle is maybe the Medicaid and preventing federal funds from going there.
Yeah, and we actually know already, and I want to talk a little bit about the regulatory intervention right now, because we know that the regulatory state, right, the Department of HHS and the Center for Medicaid and Medicare Services have actually proposed two NPRMs, notice of proposed rulemaking on gender affirming care, one of which is the Medicaid and Medicare program regulation that would specifically prevent hospitals enrolled in Medicaid and Medicare from providing most of these gender affirming care services to minors. And then also the Medicaid program, the prohibition on Medicaid and the what's called the Children's Health Insurance Program, or CHIP funding for so-called sex rejecting procedures. Again, gender affirming care, as we've previously colloquially noted it. And obviously states who want to continue doing this could continue to theoretically do so through state only funding, but it could sort of present a barrier going forward. But I'm going to ask you again, Erin, because you have experience in the regulatory state and working in this space post West Virginia versus EPA and the death of Chevron deference. Here we've got two federal agencies, or a division of one federal agency that is overseeing both regulations. Do you anticipate challenges to both of these rules when they are eventually finalized and released in the Federal Register? And what does that mean sort of post Chevron deference at the Supreme Court?
Sure. So of course, yeah, a regulation like that is going to be challenged by those who have been so bought in on these procedures that harm minors. But at least as to the portion of the HHS rule that looks at preventing federal taxpayer funds from going to these sorts of things through Medicaid and CHIP, I think that's on pretty strong footing. Congress, for of course, a long time has had the Hyde Amendment that prohibits federal funds from going to fund abortions, and then you fight about does it have to be segregated or not. But recently, when the Congress stripped funding for Planned Parenthood, there was a challenge. But even the First Circuit dismissed that. Basically, Congress gets to do with your money what they want. And so if it's a congressional policy, if it's executive policy for the HHS to not fund these sorts of things, I think that's on pretty strong ground. But certainly we will see some challenges.
So my next question is from one of our anonymous attendees, and let me direct this toward Mark, and really Erin, hop in as well. But has the sort of law related to, and again, these are all state laws, again, state medical laws related to a minor's ability to get contraception services or to get an abortion at a certain age, have abortion related parental consent laws played into context at all in the gender identity litigation, as goes to whether or not a parent must give their consent prior to actually accessing these treatments? Have they influenced any of the transgender medical litigation at all?
I would say with respect to the cases that we're working on, I haven't seen that impact play out. Again, these cases are still fairly young, 3 years, but I think still very young in litigation. These cases haven't gone to trial yet. In fact, we're just now in discovery in Chloe's case because these preliminary issues were being decided on appeal. So, the short answer is no. I haven't seen the direct impact on our litigation. Erin, I don't know if you have a different perspective, but I haven't seen it.
Similarly, I haven't seen that direct overlap as well. But it is interesting that we have, again, just to keep reiterating, the fact that you have a 13-year-old girl upon which these sorts of things can be done. Whereas, as Sarah was mentioning earlier, we've got all these sorts of laws that otherwise protect children. I think is pretty crazy.
So there's a bit of a cultural division between what voters seem to oppose and what they seem to tolerate, right? So some of the statistics that we have actually on gender identity writ large as sort of intersects with American public policy. Sports, for example, 79% of Americans of all political stripes want sports separated by biological sex. 53% of Americans oppose requiring health insurance companies to cover gender medical care for transition. So we seem to have sort of the weight of public opinion opinion, in constraining some of the expansion of gender identitarianism, but we see gender affirming care continue to proliferate, right? So in large part, we are seeing some sea changes. We are seeing individuals back off, but these are sort of piecemeal ad hoc hospitals or associations that are beginning to back off. We still know it's being done. So where do we find that disconnect? Is it simply a question of profitability? Mark, I'll kick that to you.
Yeah, I think it becomes very profitable for these hospitals that are doing this. A lot of it paid for by taxpayers, right? Places like California, if the child is young enough, the state will pay for it. We have to change that. One of the things that I've heard tossed around, I think is a brilliant idea, is if a state's going to require insurers to fund a transition, or if the state's going to pay for the transition itself, you can't discriminate against a detransitioner. And so those insurers should similarly be forced to pay for a detransition. If you do that, it's going to put a stop to a lot of these transitions that are being just forced through so quickly, right? It's going to cause doctors to do their due diligence. They're going to be required to document their due diligence, which is a huge improvement from what's happening right now. Sarah, to be honest with you, I, at this point, have forgotten where we started with that question. So can you remind me the call of the question?
The profitability of gender affirming care as a proposition, and kind of how that really is distinct from where we see American sentiment on a lot of these very common sense constraints on gender identitarianism, right? So the polling seems to indicate we want to slow down on gender transition. We want to slow down on a lot of these expansions, but the gender medicine sort of juggernaut continues to churn apace. That distinction seems to be, to my mind, and it sounds like you agree, really based on the profitability of so-called gender affirming care as an industry.
It is. It's also political pressure. I think politically, the left has to be lockstep with this transgender movement, and specifically with this false notion of gender affirming care, right? They're not willing to go against it. And so, I think what we're seeing is, while there's tremendous gains happening legislatively in states, similar to the pro-life movement, which saw a tremendous movement in states protecting life, it's created a tourism industry for transitions. We see it as a tourism industry as well, with respect to parental rights. Places like California and Minnesota will strip parental rights unless you affirm and adopt this issue. We see it in the issues of foster care. I know that our friends at ADF and us as well are litigating two cases right now in Vermont, where you can't be a foster parent unless you agree in advance that you would affirm this gender identity of a hypothetical child that's not been placed in your home. It's become very, very much politically driven as much as it has profitability driven.
So, Aaron, let me ask you a little bit about the dilemma of statute of limitations problems, and that is the fact that the clock is often very, very short in some of these cases. And there was litigation in the Second Circuit. Mary actually mentioned this in the chat, Aldeco versus Wood. The question being sort of when the clock begins to toll for these statute of limitations problems. Are there ways to get around that? Is this a legislative function of going to sort of the states in which we find these medical malpractice claim liability options and saying we really need an opportunity for these minors who are impacted by these procedures to ultimately grow up and sort of recognize the impact? How do we deal with the statute of limitations problems that are automatically sort of germane to medical malpractice cases in the first place?
Sure. So unfortunately, it's a pure state law issue. So you're going to have some states like California imposing a 2-year statute of limitations, which is insane. However, you'll have other states doing a lot longer statute of limitations, and courts are good at creating sort of equitable doctrines. Like, we all remember the case where, you didn't find the sponge when you had the botched surgery until years later, and then you could sue because of the discovery rule. So there's some things like that. I know Mark has litigated these, but between the discovery rule and the fact that you're not allowed to vote. How can you recognize the harm? Those sorts of arguments, I would hope, would have a lot of sway with courts. Again, they didn't in Kaylee's case, which is a tragedy. But the more people know about those sorts of situations, hopefully legislators and states can act and make sure children are able to get, at least some sort of compensation at the end of the road.
So sort of one last question as we're going into our final few minutes here. Courts, not like medical boards, demands documentation, right? They have to provide proof of informed consent, proof of actual standards of practice. A lot of the detransitioner litigation in California, in New York, other places could compel the disclosure of internal communications and unpublished data that would previously be under sealed record, especially so because these are minor individuals. Is that something about which we should be concerned? Is the confidentiality of healthcare information for minor children something that could be sort of an unnecessary or rather necessary consequence of a lot of this litigation? And is there a way to get around it?
So I think it's something you'd really need to discuss with your client, right? You'd have to walk through the steps, and that your name's going to be public, your health information is going to be public. Are you sure you want to do that? This is what it might look like. You're entitled to keep these things private, etc. So these brave young women are choosing to put their health information out there, and from a societal perspective, I think having information. If you look at most of these cases, you have young girls, young adolescents having top surgery based on one or two consultations that last 30 to 75 minutes. Like, that is insane. People need to know those things. And so I'm really grateful for the clients of Mark, for Chloe Cole, and others who are willing to put themselves out there and say, this is what happened to me.
Well, for everyone who's joined us today, there were so many questions, more questions for which we had time, but I'm so grateful to Mark and Aaron and Mary Margaret and to the Federalist Society for giving us an opportunity to really talk about a watershed medical malpractice case. There will be obviously more in the future. At some point, we may, as Aaron mentioned, see actual challenges to WPATH and whether or not that evidence or lack thereof is something that can be challenged. These have very evolving sort of manifestations, but we are gratified that we've seen a victory in Fox's case, hopeful for more. And thanks so much to everyone for joining us today.
Thanks, everyone.